Welcome to How to Split a Toaster, a divorce podcast about saving your relationships from True Story FM. Today, a toaster in motion stays in motion. It's Motions Part 2.
So bad. You wrote that yourself. Welcome to the show, everybody. I'm Seth Nelson. As always, I'm here with my good friend, Pete Wright. Today on the show, we're continuing our conversations about motions. As we learned last week, before we even get to trial, a whirlwind of motions, from temporary orders to demands for financial information, can have a big impact on the direction of your case. So this week, we're going to explore a few different things, Pete. Differences between evidentiary hearings and non-evidentiary hearings, because remember, motions will most likely lead to a hearing, so we need to know what we're doing. And we're going to talk through some different kinds of motions that you may or might not see in your divorce case.
Outstanding. Seth, last week on the show, I feel like this is our catch-up bit of our broadcast, of our Drama Bot broadcast. Last week, we explored motions. You introduced motions and what you might expect going through the divorce process. A motion is a formal request to the judge for specific orders. And Seth demonstrated by waving his hand in the air, saying the motion is the judge is signing his name. And that has been so easy for me to remember. I feel like I've just graduated law school. We covered various motions, including those to compel the production of documents, enforce existing orders, request temporary support or custody arrangements, and address emergency situations. And we learned that filing a motion often involves coordinating with the court and opposing counsel to schedule a hearing, ultimately aiming to convince the judge to rule in your favor. And finally, we learned that calendaring with the court is a pain in the ass. That may be the second biggest lesson that we got out of last week. It's hard.
It is difficult, but it's not their fault. Let me be very clear on the top of the show. I have one judge that I was in front of last month, I think, had over 1,000 cases.
Oh.
Typically in Hillsborough County, where we do a lot of our practice, judges have 750 cases. So there's a lot of work to be done with underfunded, understaffed. It's a big job.
So today we're talking about, we're going to be talking about the evidentiary hearing versus the non-evidentiary hearing. But first, Seth, shall we commence the motions quiz?
Oh, unannounced pop quiz? What are you doing there?
I'm very excited about this because I have a list. I have a list of kinds of motions, common motions filed during divorce proceedings. And it turns out they're not just motions. They all have names.
Okay. I don't know what you Googled to find this, but it's not on the NLG website. So
nope.
Immediately I'm going to say, don't trust what you find on any website unless it's ours. So Pete's answers might be wrong when he tells me that I got it wrong. So fire away.
All right. Let's start with one of my favorite types of motions, the temporary orders motions. So there are, as far as I gather, many different kinds of motions for temporary orders. Can you name 5?
This is like a fill in the blank? Wow. Motion for temporary relief.
Okay.
Motion for temporary child support. 1. You'll give me that one,
no,
or
2?
2?
I'm giving you 2. No, you got 2. You're 2 for 2.
Motion for temporary time sharing or parent custody arrangement, depending on what they say in different states. Motion for temporary alimony. I need money to support myself during the pendency of the case. 4. My favorite motion I saved for last since you gave me 5. Motion for attorney's fees and costs.
That one's not on my list, but I'm going to give it to you because that's fantastic. You've got to keep that one in your back pocket.
Yep. And in fact, in Florida, it's called soup money. And there's a lot of ways that you have to get there, but that is a motion that you can bring during the pendency of the case.
So we've talked about those. The other 2 that I have on my list are, it doesn't have the word motion in it, but it is a restraining order. Is a restraining order technically a motion?
That is a very good question. So that's a check your local jurisdiction answer. So in Florida, you would file technically what's called a petition for protection from domestic violence, because I'm keeping this in the family law kind of arena. Now, it expands out a little bit. When you're getting a divorce, you obviously have to be married. If it's a paternity case, you have a child together, which may not mean you're a boyfriend or girlfriend. It could have been a one-night stand, right? But domestic violence can kind of expand the scope on what domestic means. Were you dating previously? Are you married? But it would be a petition for protection from domestic violence. The layman's term, the non-lawyer term, would be restraining order, though that's technically not what it's called in court.
Okay. And how about this was the other temporary order that I found in my extensive research in the legal library, was the motion for exclusive possession of the marital home. Have you ever filed one of those?
Exclusive, yeah, it's a motion for exclusive use and possession of the marital home. So that would usually fall under when you're looking for temporary alimony or support, and basically saying, Judge, during the pendency of this case, I want to stay in the marital home. My spouse has the funds from their income or non-marital assets to go get another place, and we need to work out how the bills get paid at the marital home. And usually what happens in a lot of these temporary motions, the judge will, at the end, whatever they rule, they'll do a little comma and then write the words without prejudice, which is really important. Because let's say you're given exclusive use of the marital home and your spouse that had to move out is going to pay $5,000 a month or $10,000 a month to handle all the expenses of that home without prejudice, which means at the final hearing, at the trial, he gets to argue, Judge, I've been paying $10,000 a month for this home for a year. That's $120,000. I should not have had to pay all that money. I want some of it back, or I want an offset on anything you're going to give my spouse at the final hearing. So without prejudice, very important words, means you can still argue about it later.
Okay. Bit of a speed round. I'm going to tell you what I think a motion is, and you're going to tell me what it's called.
Let's do it. This is great.
All right. A motion is filed if one party believes the other is not providing documents or information in a timely manner.
Motion to compel.
Outstanding. Okay. Motion is used to request changes to existing orders.
Motion to amend.
Outstanding. You should be an attorney.
And not just play one on the podcast.
A motion is filed when one party violates a court order.
Motion for contempt.
Okay. How about a motion is filed before trial to ask a judge to exclude evidence or testimony?
Motion in limine.
I love that word so much. We're going to come back to that. And finally, a motion that argues there are no disputed facts in the case and the moving party is entitled to a judgment in their favor without going to trial.
Motion for summary judgment.
Those are, as far as I know, those are the only 5 that you need to be a divorce attorney.
That's it. Welcome.
How do we do? What did we miss?
So there are a lot of other motions that you can file.
Yeah.
You've actually done a very good job on hitting the big ones.
Thank you.
You've done some during the discovery phase, motions to compel. We need more financial information. Maybe there's some that you could have, if there's really troubling issues with a parent when it comes to how they parent, or if there's mental illness, there could be a motion for psychological evaluation. Maybe you want to get a third party to help out. We've talked to a guardian ad litem before, who's a neutral third party that can talk to the kids and talk to other collaterals like teachers and babysitters, like how do parents interact and what's going on. Motion to appoint guardian ad litem. There could be a motion for a social investigation, which is similar to a psych eval. Psych eval is really just what's going on in the mental state. The social investigation is kind of like a guardian ad litem, but more heavy because they usually have the credentials to do psych eval, so you can kind of lump them all into one. Motion to continue a trial.
Oh, I feel like I should have gotten that one.
Well, no, it's out there. I mean, a motion to continue a hearing.
What does that mean to continue in legal parlance?
It means, Judge, there is a procedural issue or that makes it improper to move forward with the hearing on this day. on a date that's set in the future and we need more time to prepare. Maybe the other side hasn't produced what they were supposed to do. Maybe they're in violation of a court order. So I am prejudiced because I can't properly prepare because, I need an extension of time or to change it. So there's also a motion, frankly, for extension of time.
Those seems like the same things.
It does, but one is a little different. So one is when it's a motion to continue, there's a hearing set, you're trying to continue the hearing. A motion for extension of time is you serve discovery. You say, please produce these documents within the 30 days. You can file a motion for extension of time that says, Judge, I can't get all these documents done in the next 30 days. I need 60 days, right? But I know what you're thinking. Seth, you can't even get a hearing within 60 days. So part of it is, yeah, you file your motion for extension of time. That actually doesn't toll the time. You're supposed to still produce, but judges typically don't pop you with it. But what we try to do is, even though we filed an extension, as we get the documents in, we're doing the notice of production. Judge, we're supplementing, we're doing, right?
Yeah, we're doing the work, and you at least know that you're not just sitting back and stalling.
Kicking the can down the road. Oh, another one just popped into my head and then it went out. Let me think. Oh, you do a objection. So someone asked you for documents. You object to them. The other side can set your objections for a motion, for a hearing. So it's not technically a motion, but I file an objection because they asked for 20 years of bank statements. Objection, like it's not relevant. They've only been married for 5 years, Judge, right? Then they can set my objection and see what the judge says about that.
And that, walk me through what that means to set an objection.
Like set it for hearing.
Oh, okay. All right. Okay. Separate hearing.
Yep.
Just on the objection.
Just on the objections. Yep.
Okay. So that is all.
Well, I got to tell you, I was a little nervous on the pop quiz.
You got 102% out of the thing. I mean, I don't know why you're upset.
Well, I appreciate the bonus points.
You did great. You really did great. But now we need to transition to this whole evidentiary versus non-evidentiary hearings, because that's a thing that you're going to hear in your divorce case, and we need to understand what it's all about.
It's actually a thing that you might not hear, and that's why I'm mentioning it now. Okay?
Okay.
Because
ignore everything I just said.
It's really important. It's because clients will ask me, do I have to testify? Do I have to say anything in court? And as lawyers, we get so used to being like, oh, it's a non-evidentiary hearing. Like, yeah, we got it. We're prepared. Boom, boom, boom. But the client doesn't know whether when you're going to court, whether they're going to have to say anything or not. So the first rule is when you're going to court, ask your lawyer, am I going to be expected to say anything? Am I going to be expected to answer any questions? Because that's the only thing you do in court. You only answer questions. So the first rule is you should be prepared to always answer questions no matter what the hearing is.
Because the judge could ask you a question at any point.
You got it.
Even if you're sitting in the audience or sitting behind your little table.
Well, you would be sitting at counsel table or on Zoom or what have you, right? And the question could be as simple as, how are the kids doing? Right? It could be as, well, what, if anything, are you doing to find employment, sir? Right? Now, the judge controls the courtroom. So you should be prepared to always answer questions, which means you need to follow these rules, listen to any question being asked of you, think about the question. If you understand it, answer it honestly in the least number of words as possible and stop talking. Okay? So always have those rules ready to go. But bigger hearings or anything that where you are going to be called to testify is an evidentiary hearing as opposed to a non-evidentiary hearing. So what's the difference?
Okay. What is the purpose of each of those?
Right. A non-evidentiary hearing is a hearing where the court is not going to take in any evidence. They're not going to swear in any witnesses. They are not going to take in any documents. They're just looking at the court file on what's been filed in the court, and they're hearing arguments from the lawyers. You might present a case. You might present a legal memorandum of law explaining what the issues are, explaining what the rules are, what the law is in your opinion, and then what the undisputed facts are and what your analysis is, and therefore the court should rule in your favor. So, a motion for extension of time might be, Your Honor, they filed a notice of production or request to produce documents within 30 days. Judge, I am on vacation for 2 weeks going to a family trip to celebrate a wedding, right? We're going to a wedding overseas. I'm not going to get it done. That has nothing to do with my client. We're going to work on it while I'm gone. I am unavailable, Judge. I am out of the jurisdiction. I'm asking for an extension of time.
Non-evidentiary.
Non-evidentiary, right?
Procedural. Okay.
Motion for default, which means we didn't talk about this. That's why I mentioned it.
No.
You file a petition for divorce. You have them properly served. They have 20 days to answer. They write a sticky note and say, I don't believe that this court has any power over me or my marriage. And they put it in the court file. Well, that's not a proper answer to a petition. And so I would file a motion for default and say, Judge, they didn't properly answer. You don't have to take any evidence, because I'm going to ask the judge to take what's called, or you're not going to call any witnesses. I'm going to ask the judge to take judicial notice, which technically is evidence, but take judicial notice of the court file. And then the judge is going to look at it. The guy's not going to say, well, I believe this, I believe that, and I've got 3 constitutional experts that I'm going to bring into court to tell the court why you don't have jurisdiction over my marriage, and I don't believe this is right. None of that is happening. The judge is just going to look at the file and say, you didn't properly answer, so you're in default. Motion to set aside a default. Pretty easy, right? So that would be some examples of non-evidentiary hearings. In Florida, you have mandatory disclosures. You have to do a notice of compliance of mandatory disclosures. I show up to court and I say, Judge, I'm compelling mandatory disclosures. I'm not bringing on my client to say whether they've given the documents, because the documents certificate are supposed to be filed in the court file, and then the actual documents come to your lawyer. So I'm just going to say, Judge, they never filed a certificate, or here's what's missing. Look at their compliance. We've looked through their compliance. And the judge might ask me, well, Mr. Nelson, they said they produced all the bank statements. I said, Judge, they did produce them all, but they've redacted information. And I can show you the information they've redacted. And the judge is going to kind of just take a quick look, right? So,
and this is still considered a non-evidentiary.
Non-evidentiary.
Because it's not new.
I'm not calling my client to get the document in and, or counsel, what do you say? And, you kind of work those out.
Okay. So now evidentiary hearings.
Big ones. Okay. You need to think of every evidentiary hearing like a little trial. And if you think about it, a trial is the big evidentiary hearing at the end of the case, right? Or what you hope is the end. So, witnesses will be called to the stand. Experts might be called to the stand. There will be questioning by the lawyers. There will be a cross-examination by the other lawyer. The lawyer that did the first questions, then there's cross. So it's direct, cross, then there's redirect. Okay?
Okay, can I interrupt you for a second, because this is you just changed my worldview a little bit. How many evidentiary hearings might one expect before the big evidentiary hearing at the end? How often are you going to trial, to these mini trials?
Well,
I always thought there was just the one.
No,
you do all your preparation and then you do the dance at the end.
You do a motion for temporary relief, and in that motion for temporary relief, you ask for a temporary time sharing schedule. You ask for exclusive use and possession of the marital home. You ask for child support. You ask for temporary alimony. That's like a mini trial.
And it's all evidence.
It's all based on the evidence.
That's fascinating. Okay. All right.
And here's the thing to think about. when you're going into an evidentiary hearing, the judge only sees what happens in the courtroom and what's in evidence, right? So I want you to think of a football game or a sporting event, right? The ESPN, when they're going to go through it and tell you what happened, they're not going to go through every single play. They're going to condense it to give you the main points, right? The big plays. That's what a trial is. Because I might take a deposition of a witness for 4 hours and another deposition of a witness for 2 hours and another witness, and I might have 10 witnesses that I take depositions on, and I might only have a 2-day trial. I'm not getting all of that information into a trial. We don't have enough time, because when you're doing those depots, it's very broad. When you get to trial, you've got to condense it and make it persuasive and succinct. It's better to ask 10 pointed questions in trial than 100 questions. Because at 100 questions, the judge might not know what your real point is.
When you do these depositions and then you go to your final trial, how much of, like, do the raw transcripts of your depositions get entered into evidence for the case, the trial?
You can use a deposition of a party opponent for any reason. So I always file them in court. You can also use them to impeach a witness. So I take your deposition, Pete, and you say that light was red, right? Then in court, I say to you, sir, what color was the light when the car went through? And you say it was yellow.
Oh, you caught me.
Okay. And then I say, sir, do you remember having your deposition taken on September 12th, 2024? Yes. Do you remember that there was a court reporter there recording the transcript? Yes. Do you remember being sworn in to tell the truth? Yes. Did you tell the truth? Yes. Then you got to check your local jurisdiction on evidentiary rules. I say, and I just say it. I don't ask you any more questions. Your Honor, page 37, line 4, question. Sir, what color was the light when the car passed into the intersection? Answer, red. And then I go on to my next question, and I've just impeached you, right?
Okay.
So that's one way depositions can get used. So if your deposition has been taken and you're going to be a witness, even if when you get called to the stand, you're a witness. It's your own case, but you're still considered a witness. You're on the witness list, right?
You're still a witness.
You better have read your deposition.
How often does that happen where somebody impeaches themselves because they just forgot what they said? How often do you get that?
Every day. Happens all the time, right?
I believe
But there's certain rules where you have to ask the exact same question. Okay?
Like, could I just get up on and say, look, I know you're asking me about the light, but why don't you just see my deposition? I was sworn in. That's what I said. I stand by that.
No.
Okay. All right.
Because when you're on the stand, you're not asking questions. You're only answering them.
Yeah.
Right? And this all goes to credibility.
Okay.
So very good question that you just asked. So
thank you so much.
Well, I was going to say, but you're on the stand, so I kind of let it slide.
The light is still red.
So you see the difference between an evidentiary and non-evidentiary. Non-evidentiary, the lawyer's kind of doing all the work.
Yeah.
But an evidentiary hearing where you might be called as a witness, you've got to be ready to go.
Do I have to show up as let's say I'm your client? Do I have to show up for all of the hearings, evidentiary or non-evidentiary alike?
No.
Should I expect to spend that time in court?
You should expect to. You don't have to. It depends on the hearing, and it depends on whether the court will excuse you or not.
If you, the attorney, are spending 2 weeks in the Maldives for a wedding, and you're filing a motion to extend, I probably don't need to show up to that.
Correct. Now, I have a rule with my clients. I want you at every single hearing. There's a couple reasons for that. One, you're not used to going into a courtroom. You may have never walked into a courtroom. It's a little different on Zoom, but I want you by me on Zoom. I want you focused. I want you to see the judge and how they respond. Okay. It all just gives you some familiarity, which hopefully makes you more comfortable and at ease so you can be yourself in court. The second, I think it's important for a judge who's judging you to see you, right?
Again, goes to character. Like you're showing up, you're present, you're attentive.
That's right.
No matter what.
This is important to me.
Yeah.
Right. Now look, judge, this is a motion to compel. My client is a teacher and it's the first day of school. Like you're not going to get a hard time. So what other questions do you have about evidentiary hearings?
Now, because you have so dramatically changed my worldview and the fact that these are all mini trials, these hearings, I feel like I already have a better sense of what goes into the preparation of each of these. But from the perspective of a client, what should I expect to be asked by you in preparing for one of these evidentiary hearings?
You should be asked by your lawyer or your legal team, legal assistants, schedulers, paralegals, when are you available to come in and prepare? And if you're not getting that on the calendar well in advance of that hearing, because you might need more than one prep, right? Is you should be reaching out. Hey, we got a hearing coming up in December 12th. It is now September, beginning of September. When can I get on the calendar to prepare? And what do I need to do to prepare for my meeting with you?
Yeah. Okay.
To prepare.
Two different things, right?
Right.
Yeah.
And you should be asking those questions. I personally, if available for my clients, if they're available after hours on the weekends, on big hearings or big depositions, that's when I like to prepare them. Because sometimes it takes a long time. It's something that I'm just willing to do. Not every lawyer is. Just find that it's better when you're here on the weekend and it's quiet and there's no interruptions and you're not thinking about the cases or your email blowing up all the time or doing this or doing that. And it just kind of gives you some time to really go through things, especially if it's big hearings or big, in your deposition, definitely you got to be prepared. Now, you asked what kind of questions? It will depend on the hearing.
Of course, on whatever you're trying to solve.
If we're going to temporary parenting or you're preparing for a depo on your parenting, yeah, I'm going to go through the parenting factors, right? And I'm going to take you through my depo prep that we're going to do later in the season. Like we've done it in other shows, but we're really trying to focus people on the process here. So, and we'll go through that depo prep.
So what are the other sort of red flags that I need to be on the lookout for? Because we haven't, and I'm saying this specifically in the context of motions filed against me. Like what is my perspective when motions come in asking things of me in my case that I'm not filing?
Okay. Pete, you're like crushing the questions today.
Well, thank you, Seth.
I mean, I'm not surprised, but I'm still impressed. So
I'll take it.
First off, whenever you get a motion that's filed against you, breathe. Just because a lawyer wrote it in a motion and just because the other side signed it saying it's true, doesn't mean that it's true. Doesn't mean that even if it's true, they'll be able to prove it in court. And doesn't mean that the judge is going to believe them. So read it once. Call your lawyer and say, is this something I should be worried about? On a scale of 1 to 10, how angry should I be? Right?
Yeah.
How long should I stay angry? Because you're going to want to respond emotionally to these items. And some of the stuff we look at as lawyers and we just laugh like that's never happening. Like, really? Like we walk down the hall. You won't believe the motion this guy just filed. Right. And we're like, seriously? Right. Now, you never know what happens in court. Judges make mistakes, but that's the first thing. And I say, read it once, and then we're going to go through it. I'm going to tell you, look, this is a serious motion. We got to really prepare. And what I do is I bring you in And on every line of their motion, their allegations, I want to know what's happening. Do you know what they're talking about? Do you think you know what they're talking about? What's the other side to this story? Right? So, example, there is a temporary order in place where there is a specific time sharing schedule, and you have a 16-year-old kid who is not going to mom's. Mom files against my client, Dad, a motion for contempt and enforcement and says, Dad is withholding the child. Dad's not letting the child come to my house. It's Dad's fault, Dad's fault, Dad's fault. Right? I call my client in. I already know what he's going to say. I have a 16-year-old kid who had an altercation with mom because mom did this, or that. I think, because it's hard to get info out of a 16-year-old, but all I can tell you is this kid is not going to mom's. So then I say, what, if any, consequences have you given? Because, cell phones are a motivator. Cars are motivators. Well, they used to be. Kids don't like to drive these days, right?
Yeah, they don't care anymore. It's weird.
So then we talk about that. I've taken the door off of his bedroom. I've taken his cell phone away, except when he's out, because I want to be able to get a hold of him for safety purposes. He still has his car, but only to go to his sporting events and to come home. And I tried that for 3 weeks, Judge, and the behavior didn't change. Yeah, I'm letting him go out with his friends again.
Yeah, this is where we are.
Right, which might lead me to file a motion for reunification. Because I'm going to go to court and say, Judge, mom's going to blame dad. All we're saying is we don't know what the problem is. But there's a breakdown between the relationship with mom and child, and we want a reunification therapist. Dad will go and require the kid to go, right? And, see if we can get this back on the right track.
I just want to back up and shout out again when your guidance for what happens when you get a motion served against you to stop and breathe, read it once, and call your attorney. Like, that's a perfect checklist. It makes me think of the Keegan-Michael Key acting as Obama's anger translator. Yes. You remember that bit?
Yes, it was
one of the funniest damn bits.
It was at the White House Correspondents' Dinner.
At the press corps dinner, yeah. It's just fantastic, and that's what I feel like you're setting up. Like, I'm your attorney. I'm going to be your anger translator.
That's right. And the other thing about that, lawyers only know what their clients tell them, what the other lawyer tells them, what they see in the text messages, what they see in the emails, what they see in the documents. But there's so many bad things my clients do that I don't hear about until I hear it from the other side. There's also a lot of really amazing things my clients do as parents that they don't really think about, that they're so busy trying to defend themselves or attack the other side. And I just tell them, you're a parent. Let's just talk about what you do for parenting, which has nothing to do with what the other parent is doing. Okay? So when I go through these motions and I go line by line, and I love it when they're very specific because I don't know what they're talking about other than what they wrote. I wasn't there. So then I'll ask the client, do you know what they're talking about? Oh, yeah. I know what they're talking about.
I imagine that illuminates so much. Like those incoming motions can be like a litmus test for your client's personality and experience as a parent.
Oh, yeah. No, very few clients, even though we will ask, and when we go through those 20 different factors in Florida family law as parenting, will tell us what they do bad, right? And so we really push them on that. Now, this isn't just about parenting. These motions are all over, even if you don't have kids. And, people that don't have kids, listen up. We don't know when you start hiding money. We don't know when you start having affairs or opening up other bank accounts or, borrowing money from friends to support your gambling addiction, telling them you'll pay it back later. Like, there's a lot of stuff that happens. So you got to be honest with your lawyer.
I can't think of a better message than that to end it on.
Well, I'm just glad there wasn't another pop quiz because I was only going downhill from there. You know,
You did great, man. I'm now loving this quiz model. I think we can lean in on this for future episodes. Keep a running score. It's going to be great. Thank you, Seth, so much. This was great. Do you know what we're doing next week? I believe we're going to be digging into court personnel. Who are the people that you are going to be, you're going to be engaging with through the course of your divorce process?
I'm looking forward to that. Because you might not engage with all of them, but you need to know who these players are because your lawyers are going to be saying words to you like JA, right? Initials.
Yeah, I mean, I know what that is, but others, the Rubes don't.
Yeah, exactly.
I of course, already know.
Right, so,
but
it's going to be good.
Looking forward to that. Don't forget, you can send in your questions, howtosplitatoaster.com, click on Submit a Question, and ask us, and we'll get it on the list for our bonus Q&A episodes. On behalf of Seth Nelson, America's favorite divorce attorney, I'm Pete Wright, clearly lawyer in training. I'm not a lawyer in training. And we'll see you next time right here on How to Split a Toaster, a divorce podcast about saving your relationships.
How to Split a Toaster is part of the True Story FM podcast network, produced by Andy Nelson, music by T. Bless and the Professionals and DB Studios. Seth Nelson is an attorney with NLG Divorce and Family Law with offices in Tampa, Florida. While we may be discussing family law topics, How to Split a Toaster is not intended to, nor is it providing legal advice. Every situation is different. If you have specific questions regarding your situation, please seek your own legal counsel with an attorney licensed to practice law in your jurisdiction. Pete Wright is not an attorney or employee of NLG Divorce and Family Law. Seth Nelson is licensed to practice law in Florida.